Okay, next we have Xie Liu, who's going to specifically talk about some issues with dealing with Chinese databases, something which I'm actually interested in, so thank you.
Good morning, everyone. It's a pleasure to have a speech here today. My topic is about the long-term concern on the Chinese patent pool. I'm a patent attorney from China, so my majority work is to provide a prosecution service for my clients. But we have still discussed a lot about the patent analysis and patent search. During this discussion, we found that I would like to divide the clients into two main categories. One is the leading enterprises. That means the large enterprises in the industry or some multi-international corporations. And the other one is that the growth enterprises. They are the growing new and not very large or sometimes some small enterprises in some new industry. And for these two kinds of clients, they have different problems. They face into different problems about patent analysis and patent search. For the leading enterprises, my suggestion is that they need to pay special attention on the domestic patents owned by domestic Chinese applicants. And this, especially, this refers to some utility model applications in China. And for the growing enterprises, they need a long-term attention together with the growth of the enterprises. Because nowadays, when the growing enterprises come to us for the consult or some search service, always they have already met an urgent problem. So at that time, actually, the enterprises is in a very difficult situation. So the first is about the special attention to domestic Chinese patents. This is my suggestions for some leading enterprises. The reason is we must pay a special attention to the domestic Chinese patents is the Chinese patent pool have a huge mounting number, and it still keep growing. And a high proportion of the patents are owned by domestic applicants. That means they are filed in Chinese language. And also, a very low proportion of foreign filings. That means if you just only search the databases of a worldwide databases using a different language, you may miss or ignore a lot of Chinese patents. First, the Chinese patent is also a huge mounting number. We have more than 3 million applications in 2016, and more than 1 million are invention applications. More than almost 1.5 million are utility model applications, and more than 500,000 are design applications. And still, in the first 11 months in 2017, we have still more than 3 million applications. And here is still a large number. In 2016, 42% of the worldwide invention applications are Chinese applications. And 95% of the worldwide utility model applications are Chinese utility model applications. And more than 50% of the design applications are Chinese design applications. So I would like to suggest to everyone that we may pay attention to this one, utility model applications. Here is more than 19%. 95% of the utility models are Chinese utility model applications. Here's a diagram of the preparation of the worldwide applications. Here's invention, the most with China, then US and Japan, and China is now even more than the summary of the US and Japan. And here is the utility model. It's true that because in a lot of countries they do not have a utility model system, but it's true that China have a very, very large amount in utility model applications. And here is a design. And still, even with a large basis number, the Chinese application is still keep growing in number. Here we can see the number of the Chinese applications from 2012 to 2017. That is keep growing. And in the last year, the growth seems to be a bit lower, but still we have a very, very high total number. And also, in 2016, China has the fastest growth in IP5 countries. That means in 2016, China has a growth of more than 20% compared with the 2015. And then the United States is about 3%, and the European Union, Japan, and Korea is negative growth. And also, it's another characteristic of the Chinese application is that a high proportion of domestic applicants. That means in 2016, overall there are more than 95 applications are filed by domestic applications. Within there, more than 90% invention applications, more than 99% utility model applications, and more than 97% design applications are filed by Chinese domestic applications. So we should still pay attention to this number. More than 99% utility model applications are filed by Chinese domestic applicants. And if we pay attention to the previous slide, most of the utility model applications worldwide are Chinese utility model applications. So in the field of utility model applications, actually a lot of them are filed in Chinese and only effective in China. So we must pay attention to this kind of applications. And here's the data about the 2017. It's January to November. It's also have a similar situation. That's a very high proportion of domestic applications. And this diagram shows the proportion of the domestic applicants. And also, Chinese applications have a low proportion of foreign filings. That means it's quite difficult to find a complete China patent portfolio if we just pay attention to the international databases. And only a small proportion of the Chinese applications are also filed in another country or region. Here, this table shows the applications filed in 2012. And because of the later publication in national stage, this is the latest data about all of the family applications. So we can see that China, we have any family in a different IP file, just only 3.4%. And in any other country, 3.6%. But compared with the other countries in IP5, United States, European Union, Japan, and Korea, they are much higher than China. So that's true that United States and the European Union, they will use English. Do not have a problem in language. In Japan and Korea, though they have they use Japanese and Korean, it's some difficulties for search in language, but they have a high proportion of foreign filings. It would be more easy for you to find a family application in a different language, maybe in English. But China, this percentage is quite low. So a lot of cases, you cannot find a family application in English. It's only in Chinese. And here is a diagram shows the proportion of the foreign filings. The China is obvious much lower than the other countries. So here's the suggestion for the leading enterprises. I believe that for most of the leading enterprises, they already have a quite good internal evaluation and monitoring system for the patents all over the world. But sometimes they may miss the patents which are published in Chinese and owned by Chinese and only filed in China and effective in China. So we should pay special attention to these patents if you would like to use the Chinese market as a main market. Especially as we discussed above, these are means to Chinese utility models. The Chinese utility models, it's have a large number and it is useful. During a litigation, it almost have the same power as the invention. That we have a Chint versus Schneider cases. This is a case which have the highest damage even in China. And Chint is a Chinese company, and this case was based on a Chinese utility model patent. Schneider is a multinational corporation. I believe they have a very good monitoring system, but it is possible that they have missed the Chinese utility model application because it was only in Chinese and their searching system may missed it. So actually, the resources are available for all of the Chinese patent portfolio, even including the Chinese utility model applications. We can use the website of Sample. It's free, but it's in Chinese. And we can also have some commercial patent databases. They have already included the Chinese utility model patents. So my suggestion for the leading enterprises is that you must pay attention to these Chinese utility model patents. And then the other category of the clients, that means the growing enterprises. So the growing enterprises, during the current situation, when they come to us, they are looking for a report of FTO. The reason is that they are facing to some urgent challenges. They may have a product what is ready to launch, or they are looking for a financing and investment, but they have made some problems and they need the FTO. And it is very critical to the enterprise at this stage. As my colleagues partners have introduced previously, the requirement of TO is quite strict and high. They must very accurate understanding of the technique, and you have a very complete and clear search, and so as to, for the purpose of you do the search as complete as possible, you need to use at least 2 independent search tools. And then we need to screen the suspectable patents. And in this stage, we need the input of experts and attorneys, and also the evaluation, the risk of infringement. And it's always in a short time because you are always facing to an urgent matter. So the FTO, as a result, for growing enterprises, they will feel that FTO is really expensive, it's high workload, and it's high pressure, because I mean that the situation is we are now facing in China, that when the growing enterprises, they need to do the FTO. They have already invested a lot in this field. They have ready to do their products, or they have a very urgency financing for the company, but they have met problems. So we can say that the result of the FTO is critical to their company. So if the result of the FTO that the risk is not so high, it will be good news. But if the result of the FTO that the risk is very high, the enterprise will be in a very difficult situation, because it has already invested a lot, or it's waiting for a new financing, but the risk is very high. The only way they can choose, maybe they initiate a validation procedure directing to the targeting patent, or they will go to litigation. Which, either way, is bad news to the company. And the companies at that time, it's growing, it's not so small. It do not have a very solid financial system, so it's a very big problem to them. So my suggestion to these are that for these companies, they need a long-term monitoring. They have a need to some search for early warning. They need to understand the current status and trend of their industry which they are in. And for this purpose, they can use one such tool. It will be sufficient. And the search for early warning can guide the right technology path, and that means they can invest in the right way, and they can avoid the risks as early as possible. And there is no time limit, so the complete work is not very urgent, so it's not very high pressure. And if establishing a long-term monitoring mechanism on patents, most basic works can be done in-house, and you can utilize the free patent database or commercial patent database with limited budget. So it will be more suitable for growing enterprises. But we still suggest that you need to cooperate with the professional institution. The first reason is that the professional institution will help you to optimize the monitoring system and to help you to build a good system, a good internal system. And the professional institution will help you to eliminate particular risks, because for particular events, particular projects, we need FTO, or we need some lawsuit, some litigation procedure. At that time, you need professional institutions. But, if you have a long-term internal system, you can, the services provided by the professional institutions with a limited workload and limited cost. It will be quite good for a growing enterprises. So that's all for my presentation. Thank you for your time. Thank you.